Yes, Mr. McDonald.
May it please your lordships, your ladyship, I appear on behalf of the appellant with my learned friend Mr. Brownlee. My learned friends Mr. Duffy and Mr. Curran appear on behalf of the respondent. My lords, my lady, this appeal concerns the effect of Section 160A of the Proceeds of Crime Act, which was inserted by the Serious Crime Act 2015 and came into force on the 1st of June 2015. The Court of Appeal has certified two questions for this court. First is where property is held by the defendant and another person, in what circumstances is the court making a confiscation order required by Section 160A in determining the available amount to give that other person a reasonable opportunity to make representations to it at the time the order is made. The second question does not flow from the first because of a late amendment. I recall that, in fact, the dangers of drafting on the hoof were referenced at the time, and indeed they've been borne out. What had been added was it had initially read the first question without the line in what circumstances. But in any event, the second question is if Section 160A does so require, does a failure to give that other such an opportunity render the confiscation invalid? The first question relates to whether the effect of the introduction of Section 160A is now to require a court in every case where, as a matter of fact, there are jointly held assets or jointly held property which are likely to be used to satisfy the order. The question is whether it's now to require a court in those circumstances to proceed by way of Section 160A and make a conclusive determination of a defendant's share in property, and therefore, as Section 160A requires, give a third party, another person with an interest in the property, an opportunity to make representations. We submit that the plain answer to that question is no, that it was not the intention behind the introduction of Section 160A. We suggest that rather the purpose was to enable a court in appropriate cases to conclusively determine a defendant's share in jointly held property in order that the confiscation process might proceed more efficiently. That is, it creates a power where the judge can enabling the judge to relatively quickly deal with simple cases within his or her competence. But that in other cases, and perhaps one example may be where the property issues involved are more complicated, in those other cases, the value of a defendant's share in property can be decided or calculated in the way that it always was before the introduction of Section 160A.
Why was Section 160A required then?
Well, there is a decision to be made by a judge as to whether he proceeds by way of Section 160A or simply follows the legislation that pre-existed Section 160A and has not been altered in any way. So that is the choice we say that is available to the judge in a confiscation order.
But why should that choice be available to him?
To enable him to decide simple cases and proceed efficiently so that third-party interests can be disposed of and determined in simple cases.
So then there's a conflation of the confiscation order and the enforcement order stages, is there?
Well, that's effectively what Section 160A does. It brings them
in
together.
simple cases.
But the point is simply that it creates a power. And as I'll go on to
But in the circumstance where that amalgamation, so to speak, of the two stages is appropriate, the judge would have to be apprised of all of the relevant circumstances in order to identify or characterise this as a simple case.
Well, indeed, but he has the option to leave it until enforcement if he wishes to. And that is rather the practical problem of this. Because if Section 160A does require him to make a conclusive determination and determine difficult third-party rights, then hearings can be conducted and court time used.
Well, how does the judge signify that he has, or she has, concluded that this is an occasion for amalgamation or conflation of the two stages, or it's merely a provisional confiscation order which is subject to variation under, I think, Section 173, and the enforcement stage is to follow? I mean, is there some formula that is employed by a judge to indicate to the parties that this is a final order or that it's merely a provisional order? Well,
there is, and I'll take your lordship to Fulham in due course, but we suggest that the proper approach is for the judge to signal that he wishes to proceed under Section 160A and make a conclusive determination.
Well, that didn't happen here, did it?
No, it appears he wasn't even aware of Section 160A, as indeed it was the case in Gulam.
Mr. McDowell, in the Gulam case, and by the way, the last page of the Gulam report wasn't copied.
Can we rectify that?
Well, I mean, I've got a copy, but and it may be that everybody else, apart from Lord Lloyd-Jones, is working on a computer. Well, there is no analogous problem. I can give a copy to my colleague.
I'm afraid there might be on computer.
But I raised it in order to say that in paragraph 91, Lord Justice Holroyd says, in such a case, it will be necessary for care to be taken in completing forms 5050 and form 5050A so as to reflect the court's determination or decision not to make a determination. It crossed my mind when Lord Kerr was asking you about, well, how does the court make clear what it's doing in this context, that possibly these forms might illumine that?
Yes, my lords. The same forms do not exist in Northern
They
Ireland.
don't?
No, but there's no reason why they should not. But in any event, the judge could make clear in his oral ruling or that he is making a determination under Section 160A rather than proceeding as one would have done before the Serious Crime Act came into effect.
Suppose one had a mother who had small children, obviously couldn't work, and the only asset she had was her interest in the home. And there would be obviously an issue about selling the house with the children and all the rest of it. Wouldn't it make sense if the judge said, well, I can determine that she pays so much per week? She obviously can't do it. So let's collapse the procedure and determine in these proceedings at stage one what her interest is, and therefore save valuable court time in the Crown Court.
Yes, absolutely. And we don't suggest that the judge cannot do that. We say that in appropriate cases, and that may be an appropriate case, the judge can do that. We simply say that the effect of the judgment of the Court of Appeal was to make it mandatory. Now, that's not how it was expressed in the Court of Appeal. The only reference to mandatory was whether the third party had to have the opportunity to give representations, but the effect of it was to say, as soon as a judge makes a determination of share in property, then he is proceeding by way of Section 160A, whereas we say that he can do so, and indeed is obliged to do so, through Section 156(5) in deciding the recoverable amount. Right. As was always the case prior to the Serious Crime Act.
But in answer to my Lord Kerr in the chair, there is a good purpose for having Section 160A in those sort of cases where you can foresee that you're going to have to go to the second stage. There isn't any possibility.
Yes, indeed, but the majority of cases don't reach the second stage.
Yeah.
And if Section 160A is the only mechanism by which one can determine a defendant's share in property, then third parties are required to be notified.
Yes.
if they don't fail to answer, then further delay is incurred. They may wish, and these are practical difficulties that have occurred, they may wish to seek legal aid, and problems of that type can simply have the opposite effect to that which Parliament intended in bringing in Section 160.
It's simply an additional option in the judge's armoury.
Indeed, and that's our simple submission in this case.
Can I just ask, Mr. Justice Deeney's judgment, was it delivered extempore?
Yes.
Yeah, thank you.
Of course, he followed it in McLaughlin and Grew, where the composition of the court, that there were two members of the court common in that case, but of course, by that stage, he was bound to follow it.
Yeah.
But it was extempore, yes.
Right, well, where are we now, Mr. McDowell?
Well, we're rather well through it. If it would be of assistance, however, I was going to go back to go through with your lordships and your ladyship the legislation as it did operate, and if I can go to that. It's paragraph 8 of our written case, and it may just be of assistance throughout paragraph 7, but also to turn up the authorities volume, tab 26, MS 520.
Yes.
And plainly under section 156(4)(c), because this was not a criminal lifestyle case, the court must proceed as follows. If it decides that he does not have a criminal lifestyle, it must decide whether he has benefited from his particular criminal conduct. And then subsection 5, if the court decides under subsection 4(c) that the defendant has benefited from the conduct referred to, it must, and I emphasise that, decide the recoverable amount and make an order. From there, we go to section 157, which makes it plain in subsection 1, the recoverable amount for the purposes of section 156 is an amount equal to the defendant's benefit from the conduct concerned. But if the defendant shows, and that may have some importance in the examination of this case, if the defendant shows that the available amount is less than that benefit, the recoverable amount is the available amount, or a nominal amount if the available amount is nil. So the onus is on the defendant to show that the available amount is less than the benefit, but nevertheless, the court is obliged. Any discretion of the court to proceed under this was removed in the mid-90s in both jurisdictions, I think. We then can turn, and it might be of assistance if we go to the written case for this, because one has to hop around the Act rather, MS 35. Paragraph 10. The available amount is defined by section 159, which reads, for the purposes of deciding the recoverable amount, the available amount is the aggregate of the total of the values at the time the confiscation order is made of all the free property then held by the defendant.
Can I ask a question about that?
Yes.
Mr. McDowell? How can the court determine the value of the free property then held by the defendant in relation to a property in which another person has an interest without determining the extent of the other person's interest?
Well, our answer to that is that they can't. And we accept that that is a difficulty, but it is a difficulty in the drafting of Section 160A.
Well, I think your answer might be modified. The court can't, with any finality, determine that. But if, as in this case, Ms. Hilton comes to the court and says, well, I have this property and it's valued at such and such, but my estranged partner is entitled to a half share, the court can make a provisional assessment.
Indeed, my Lord.
But I think, if I may say so, the more accurate answer to my Lord's question is that the court can take a decision based on the evidence available to it at the time.
Quite.
But in the background, there is always the possibility that with further elucidation and with the adducing of further evidence, a different view might be reached.
My Lord, yes, the prior to Section 168, Section 156(5) requires the court to decide the recoverable amount, and the word used is decide, whereas the word used in Section 160A is determine, and I have pondered in the course of my consideration of this matter as to whether there can properly be a distinction between those two words. But on the basis of the intention as disclosed by Parliament, as by the explanatory notes, there must be, if not a distinction between those two words, certainly a distinction between the procedure under 156(5) and that under Section 160A, and determine if there is a difference between the two words is a more final.
But it's the real distinction, this. It's not so much that it's only provisional, but that it's not binding on the other owner.
Yes.
I mean, one can see a situation where, for example, somebody dies as a co-owner of a substantial property, and that their share forms part of their estate for the purposes of inheritance tax, and there might be a dispute with the revenue as to how much tax they should pay. Ordinarily, that would be sorted out as between the revenue and the estate of the deceased co-owner, without necessarily having to join as a party. Indeed, it would be most extraordinary to join as a party the other co-owner. It would be a final and binding decision in the upper tribunal of the tax chamber between the revenue and the estate of the deceased co-owner, but it wouldn't bind the other one.
No, indeed. Just as this will be a binding decision between
Yes.
the defendant and the prosecution,
Yes.
but not against the third party,
Yes.
until enforcement.
Yes. Well, enforcement, even then you could get a charging order over the defendant's share of the property, which wouldn't be much use to you, but if you wanted to enforce by getting an order for sale of the property itself, you'd have to join the other co-owner, at which point that co-owner could have a free to say what his share was.
Yes, indeed.
I fully understand the enormous practical pressures on Parliament in devising this, not to burden the Crown Court judges at the confiscation order point with elaborate inquiries that I still do have, despite the contributions made. I do have some difficulty with a confiscation order which produces an actual order, which then has to be complied with in circumstances in which it might not be accurate. I mean, if Ms. Hilton had said, I know this property is in joint names, but actually the contributions made to it by my former husband are such that I've only got a 10% interest in it rather than a 50% interest. And if the judge had said, no, I don't agree with that at all, you've got a 50% interest. If it later turned out she was quite right, there would have been a confiscation order made on an erroneous basis. And I have some difficulty with that.
Well, my Lord, one must look at the purpose behind the Proceeds of Crime Act, because in this case the benefit was some £16,000, and the purpose behind the Act is primarily to confiscate ill-gotten gains. And if the situation arises that slightly more is paid than ought to have been paid, in order, for instance, to avoid a term of imprisonment in default, then that is nevertheless satisfying the aim of the legislation. But if, for instance, a third party wishes to exercise their rights and hold them dearly, irrespective of the imprisonment and default, then they can wait until the later stage, if they wish, and still have those rights respected. So the answer, I think, to your Lordship's question is, well, perhaps that is right. Perhaps it may result in a greater share forming the part of the recoverable amount, but given rise to the overriding purpose of, or considering the overriding purpose to the 2002 Act, then that does not present as much of a difficulty as perhaps in another situation.
Well, thank you.
Mr. McDowell, in a situation where the procedure under Section 160A is not followed, what procedures are available to the defendant and to third parties in order to vary or to set aside the initial order which is made in the Crown Court? Well,
If one proceeds under what I'm describing as the old way, but in fact is also in
the original provisions.
Yes, then the procedure is simply that they can make representations on enforcement.
In the Crown Court?
In the Crown Court, yes.
Is that under Section 173?
No, that's 173 concerns the alteration of the available amount. It's under Section 199(8), which appears at MS 580. It's the powers of enforcement are at 198 and 199, so it's MS 579.
So what's the provision then?
It's Section 198 allows the Crown Court to appoint a receiver. The powers of the receiver are then specified in Section 199. And those powers...
Well, under the old system, if a confiscation order has been made and on further analysis it proves that the amount ordered to be repaid is inappropriate, for instance, because there's an interest in the property which is in excess of that was originally perceived to be available to the defendant in the confiscation proceedings. As a matter of mechanics, how is that dealt with? Does a receiver have to be appointed?
Yes, if the money is to be sought and obtained other than voluntarily.
Right. Well, let's suppose, let me take this case as an example. If Ms. Hilton is required to pay 50% of the proceeds of sale, and then it transpired that her estranged partner had in fact a 70% interest in the property, how would it work? I mean, does she apply to the court to appoint a receiver, or what happens?
The prosecution applies to the court to appoint a receiver.
Well, what's the catalyst for the prosecution's application?
The failure to pay.
I see.
And then under Section 199, subsection 8, the third party will have a right to, which mirrors that in Section 160A.
So as a matter of practicality, what happens is if Ms. Hilton failed to pay, the prosecutor would apply for the appointment of a receiver under Section 198.
Yes.
And then the panoply of powers under Section 199 would come into play.
Indeed.
Right.
What would happen if, instead of allowing the matter to go to the point where the prosecution has to apply for the appointment of a receiver, the defendant pays off £40 a month in accordance with an order, she could go on paying that until she's paid an amount greater than she should be paying.
Well, she is afforded a time to pay, which is a maximum of 3 months presently, and can be extended to 6 months under the Serious Crime Act. But once that period is concluded, she becomes liable to a term of imprisonment and default.
She might, during that period, pay off more than she should.
She might, but that's she will be paying off the confiscation order, which and the overriding objective of the Act is to recoup the figure for benefit, the amount that she has benefited from the crime, which in this case was £16,000.
So it's rough and ready.
Well, it is, but it's the overall scheme is I'm not going to adopt the phrase, but it is the point of it is to recoup ill-gotten gains.
Well, in any event, she will not have to pay off more than she actually got by dint of her criminal activity.
Precisely.
Yeah. But it may be, if she has not been as assiduous as she might have been, she will pay back more than she could have got away with, so to speak.
Indeed, and the criminal justice system it contains other instances where someone might do something, for instance, borrow money in order to satisfy a fine from a family member, where that family member waives their rights to that money in giving it to them, in giving it to the defendant to satisfy the order, in order to avoid a term of imprisonment. But that is a choice that the third party, the family member, can make if they don't want to see their loved one go to prison.
I'm not sure it's quite the perfect analogy. I mean, here, in my Lord Jones's example, in fact, it might prove that Miss Hilton will pay more than she could have been made liable to. And that's got nothing to do with the beneficence or generosity of a family member. It's just the circumstance that if the full facts had been examined and known, she may pay back more than she could have been required to under the legislation.
Yes, well, I agree. Well, equally, as a family member might pay more, she may pay more in order to avoid, rather than seeking to exercise her property rights and saying that she was liable, she only held a lesser share.
Okay.
But these are choices to be made, and one has to look in this appeal at the intention behind Section 160A. It was not to rectify a perceived problem in the 2002 Act that existed, and of course the matters that your lordships raise existed prior to Section 160A. Section 160A was not seeking to rectify that problem of someone who, in respect of whom a determination is made that they own more share than they actually own, nor was it to prioritise third-party rights. The point of it was to increase efficiency and to deal with third-party rights swiftly to prevent them stalling the overall proceedings.
Well, in effect, you say that resort should only be had to Section 160A, where the judge is confident that she or he has sufficient information to move directly to the enforcement stage of the proceedings. Is that
And
right?
is also content that they have the ability to deal with it.
Yeah.
And a good example of that is the Taylor and Butler case, where Mr. Justice Turner felt that he was in a position to make a determination.
Yeah, but as I understand it, your submission is that the judge should only have resort to Section 160A where she or he is in a position to be confident that they have all the information necessary to allow them to proceed directly to the enforcement stage of the proceedings.
Yes.
Mr. McDowell, can you help me on section 199? Assume there is a case like the present where there is not a determination. Well, let's assume there wasn't a determination under 160A, and the defendant is assumed or determined to own half the property, doesn't pay, and the prosecutor gets a receiver appointed under section 199. The co-owned matrimonial home is part of the realisable property, isn't it? Because it's within the definition of free property.
Yes.
So that if the receiver's given powers to take possession, deal with, realise, i.e. sell the property, that would be the whole property, not merely the defendant's share in it.
Yes.
And what happens in that situation? Up to now, the co-owner hasn't been involved in the proceedings at all, may not even know about the proceedings. So what happens? The receiver comes banging on the door and says, I got a court order to get you out. Out you go. And what's more, I'm going to put it on the market.
My Lord, subsection 8 at MS 580 at the bottom of the page states that the court must not confer the power.
So that process comes in at 8. Yes, I see.
It does. So it mirrors section 160A to that extent in giving third party the opportunity to
But is it correct that,
make representations.
I don't mean to doubt, my lord, that the receiver would have power to sell the husband's share, because the only property which is free property is the interest that the wife may have?
Well, one couldn't sell simply.
No,
half
you'd
of
have
the
to go for an
property.
order under section 30 of the Trustee Act
Yes.
to get an order
So
for
it
sale.
would have to be, but with half of it obviously going to the husband.
But does
Because
Mr.
free
McDowell, is the answer to my lady's question not to be collected from section 232(2)(a)?
that is the property.
If somebody holds a 1% interest in a property, the whole property is held by that person.
Yeah.
Isn't that the effect of that subsection, that paragraph?
It is, but the difficulty is that in the 2002 Act, property is used when one is dealing with the whole of the property. The term property is used when dealing with the whole of the property. But
That's,
it's
I think,
also-
what I'm saying. That's what I'm saying. Property is held by a person if he holds an interest in it.
But it is.
The respondent here holds the property, even though she's only got less than 100% interest in it. Isn't that right?
Well, it is, but I'm hesitating because property within the Act can also mean the defendant's share in a property.
Ah,
Yeah.
And
Could be that if means if and to the extent that.
so, forgive me, milady.
I'm sorry, I didn't mean to interrupt you. If may mean if and to the extent that.
Yes, indeed. And if one follows through and we've gone through it in regimented fashion in our written case. And at MS 35, paragraph 11, section 232(2)A,
yes.
well, it's perhaps better to go back to section 159,
Yeah.
which is that for the purposes of deciding the recoverable amount, the available amount is the aggregate of the total of the values of all the free property then held by the defendant. And then
Well, that
section 232(2)A, give me my lord, property is held by a person if he holds an interest in it. And then section 227 makes it plain in subparagraph 3 that if another person holds an interest in the property, its value in relation to the person mentioned in subsection 1 is the market value of his interest at that time.
Yeah.
And of course, this is all under the mandatory power, the mandatory provision of 1565, which requires a court to go through this rather complicated route around the legislation.
Can I just come back to 1998? I thought you had satisfied me on it, but I've got one continuing problem. It's on page 580.
Yes, my lord.
You say the answer to all my problems arises from 1998. The court must not confer the power mentioned in subsection 2B or C, or exercise the power conferred by 6, without giving the opportunity to other persons holding interest to make representations. But what about the power in 2A to take possession? Does it still mean that the receiver can be given power to take possession of a matrimonial home in circumstances where, for all the court knows, the other matrimonial home co-owner won't even know about the proceedings? And the first thing he knows is the receiver arriving on the door saying, I've got a possession order. Because it's only B and C, that is management and sale, which is caught by subsection 8A, and 6 is about something else, which is making the co-owner actually make a payment. But that's in fairly specific circumstances.
Yes, my lord, I accept your lordship's point.
So, I mean, what happens? Does the court nonetheless, before it decides to confer a power to take possession on a receiver, check whether there are any other third parties who might be affected by being kicked out?
Well, of course, this provision only states what's required of the court. The court can always take into account other information and evidence in making any order.
But is the application for a receiver made on notice to the defendant?
Yes, it is.
But then not to anybody else? How will the third party, where an embarrassed defendant hasn't told the third party anything about the proceedings, know that the receiver's being given this power over a property which he may own 90% of?
Well, that is, I accept that that's the case.
Yes.
If that is a problem, it's a problem that existed before Section 160A, and the intention of Section 160A was not to solve it.
Yeah. In other words, it is a problem. There isn't any other solution to it, but you say it's got nothing to do with the construction of 160A.
Indeed.
Yeah.
Mr. McDowell, under the original provisions, if a third party has an interest or claims an interest in the property, mortgage company or husband or partner or whatever, is there a procedure by which an application can be made to the Crown Court other than being heard on an application to appoint a receiver?
Well, if they are aware, there is only a duty to inform that party if one is proceeding by Section 160A or Section 199.8.
Right, but if they're aware.
But if they're aware, they can give evidence. They could give evidence on behalf of the defendant. For instance, in this case, if the husband claimed more than Mrs. Hilton.
But at what stage?
At the confiscation hearing.
At the confiscation hearing itself?
The husband could be called as a witness by either side, theoretically, depending on the extent of the interest claimed by him.
When the mortgage company finds out, after the confiscation order's been made, is there a procedure by which they can apply to the court to set aside the confiscation order?
Under the old regime?
Under the original regime? Or do they have to wait until there's an application to appoint a receiver?
Well, they could make an application under Section 173, as my Lord Kerr has suggested at an earlier time, which to vary the order. Oh, forgive me.
It's on inadequacy.
Yes, indeed. In fact, it's only the defendant or a receiver that could make such an application.
Yes.
I suppose the mortgage company might, if it becomes aware of the appointment of a receiver, might draw it to the attention of the receiver, in which case that might prompt a...
Yeah, yes, indeed.
Thank you.
Right, where are we now, Mr. McDowell?
We might you might think it useful for us to go to section 160A.
Yes.
Mr. Duffy will make his position clear. I can't think he's going to tell us that the subsection 1 is mandatory. He's certainly going to tell us that what the judge did in this case was determine the extent of the defendant's interest, 50%. So he was making a determination of under section 160A. And we believe that you are challenging that, Mr. McDowell. So it might be helpful for you to expand on that point.
Well, the section, plainly unlike section 156 and the sections that flow from that, which concern the making of a confiscation order and deal with a simple arithmetical exercise, as Ahmed and Qureshi makes clear, of totting up the values of the property held by the defendant, or the share of property held by the defendant. Section 160A is concerned with, to a degree, with the realisation of the property as well. We submit that it is clear from the language of the section itself, but also from the parliamentary intent behind it, as evidenced in Hansard and also in the explanatory notes, that it is a power. And it is not a power to make a determination or to decide a defendant's share in jointly held property, because there would be no need for it if that were the case. A duty already exists to determine that share or to decide that share. It's plain if one looks at subsection 1 that the words, "The court may, if it thinks it appropriate to do so, determine the extent of the defendant's interest in property," is conferring a power. And one that is different, we submit, to that under 156(5). The difference being that it is a conclusive determination, it is binding.
So the Crown Court judge did not determine the extent of Ms. Hilton's interest in the property, even though he took 50%.
Not for the purposes of section 160A.
Not least for the prosaic reason that it wasn't drawn to his attention.
Indeed.
I mean, he can hardly be indicted for having exercised his power or duty, or however you describe it, under 160A if he was unaware of it.
Indeed. The court is obliged by the 2002 Act to decide the extent of a defendant's share in property. It was obliged before the Serious Crime Act, and it must therefore, and has done in many cases, come to a conclusion about the percentage of the property held by a defendant. But our point is simply that that is different to the power confirmed by section 160A, that the judge was entitled to proceed down the route of the original legislation, which is a route that is still open to him. And the effect of the judgment of the Court of Appeal in this case is to say, well, although the court must always, according to section 156(5) and the sections that follow it, the court must always decide the value of a defendant's share in jointly held property. Then, if the two preconditions in section 160A(1) exist, then it must proceed by section 160A. That is the effect of the judgment of the Court of Appeal. Because if the Crown Court is going to say, well, how much property of this property was held by Mrs. Hilton. As a matter of fact, it was the only property available to her, so it was likely to be realised, the first precondition. And of course, the second precondition already exists because a person other than the defendant holds the property. And the effect of the judgment of the Court of Appeal is to make it mandatory to proceed by Section 160A if the court wishes to decide the share of a defendant, which it is obliged to do in assessing the recoverable amount.
In other words, it makes the words in 160A(1) may, if it thinks it appropriate to do so, entirely otiose.
Entirely. And indeed, subsection 2 speaks of the power conferred by subsection 1. The references to Hansard, which are included in both the appellant's case and the respondent's written case, all consistently and repeatedly reference the power created by this subsection or this section. And but there is no power if the interpretation is simply that every time there is a share of a defendant's property to be considered, then one must proceed by Section 160A. And we say that is that.
Well, presumably
they fell into error in doing so. Forgive me, Lord.
There'll be numerous cases in which the confiscation order is for an amount well below the available property. I mean, somebody may hold available property, including a share in a jointly owned home of, say, $500,000, where the confiscation order is for 50,000.
Yes, my Lord.
But in cases where the available property is only or is mainly a share in property, and where the whole of the person's available property is going to have to be realised to pay the confiscation order, then the circumstances contemplated in subsection 1 are going to arise, aren't they?
Well, that's correct, but the opposite is ordinarily true, where the benefit figure outweighs the available assets.
Yes.
That is much more common.
Yes.
And so if one's obliged to proceed by Section 160A, all the practical difficulties which I've outlined to the court will exist in every case.
But if it's likely that the property is going to have to be realised in order to pay the confiscation order, which is what 1A contemplates, and somebody else has got an interest in it, so sooner or later that property is going to have to be sold, why would it be a sensible exercise of the discretion not to bring that third party on board at that early stage?
Because ordinarily confiscation orders are paid by one means or another.
Without a sale.
By remortgaging. And why have an unnecessary hearing with evidence and people requiring to be notified and perhaps legal aid being sought when one can simply follow the presumption, which was accepted in this case as it happens, that Mrs. Hilton owned 50% of the property. So it creates a wholly unnecessary step and has the opposite effect of Parliament's intention in enacting Section 160A. Can I take your lordships to the explanatory notes, which we submit in this case do cast light.
Just before you leave the statute, do we get any assistance from Section 166(6)(a) and Section 168, which enable the court to require information if it decides to go down the Section 160?
We do, my lady, because it makes it plain within that section that, it reiterates that it is a power and it's a decision on the part of a judge to consider whether to make a determination under Section 160A rather than proceed as one would have done before the 2015 Act.
And you've got to make a conscious determination to make a determination.
Indeed. Which, of course, did not happen in this case or indeed in Gulam.
For what purpose are we going to the explanatory notes?
To show the intention of the government, which was then adopted by Parliament in our submission.
The mischief at which it was aimed.
Yes.
Thank you.
Paragraph 19, it's MS 477. Sorry, tab 19, for those who are dealing with a hard copy bundle.
Yes.
So, what in the first sentence? Most appropriate for third-party interests to be dealt with substantively at the enforcement stage, given that the existence of such interests only crystallizes against specific property at that stage. What's meant by that?
I think, my lord, that is recognition of the fact that there are many ways of satisfying a confiscation order, which would not involve the final determination or the final dealing with property, which is included in the available amount. So, for
The
instance,
existence of the husband's interest in this property only crystallizes. The existence of the husband's interest only crystallizes against this property at that stage. How can that be right?
well, my lord, it was open to the parties in this case to secure a loan of some sort against the property in order to satisfy the order.
Well, I think my lord is right to point out that it's a somewhat incongruous use of the verb crystallizes. I mean, the existence of the interests predate any confiscation order. I mean, if the husband or a estranged partner has an interest in it, it doesn't crystallize at the time of the making of the order. It has an anterior existence.
I accept that, my lords. What I can say that this is a particularly bad case to demonstrate the point, because it is so simple. It is likely to be a 50-50 case, and it may have been one which was ripe for a Section 160A determination. But
Only His Honour Judge Miller knew all about it.
well,
Yeah, well, in any event, I think what somewhat inelegantly, if not indeed incoherently, the first sentence of paragraph 19 is seeking to convey is that the threat to the interests of the third party only crystallizes at that stage. It's not so much the interests are there already, but the possibility that they will come in jeopardy crystallizes at the stage when enforcement is reached.
I think that might be right, Miller.
Yeah.
Yes. In any event, continuing, however, in some cases, waiting until enforcement to determine the extent of a third party's interest in the defendant's property can complicate, lengthen, and otherwise frustrate the confiscation process. Those are sentiments which are echoed throughout the parliamentary debate.
Yeah.
With the opposition, of course, wanting it appears wanting the third party interest to be dealt with with restraint, but in fact, but the government, the whole scheme behind these amendments were to enable more efficient dealing with third party interests.
So to go back to my earlier question, this provision is intended to provide a procedure that was not available under the original
Yes.
scheme, whereby an application can be made before you get to the enforcement stage of appointing a receiver.
Absolutely, but it's an available provision, but it's not a mandatory one. Then paragraph 20 makes it plain that it is a power, something reiterated throughout Hansard, the Hansard references. And then 21 makes it clear what the intention was, it was envisaged that the Crown Court would only make such determinations in relatively straightforward cases, such as the instant case, perhaps. That is where the court considers that it can, without too much difficulty, determine the defendant's interest in particular property and deciding whether to make a determination in any particular case. It is expected that judges will exercise the power to determine the defendant's interest in property only in those cases where their experience, including in respect of matters as regards to property law, the nature of property and the likely number and or complexity of any third-party interests allows them to do so.
I'm slightly puzzled by that. I mean, assume that it's actually quite a difficult question what the relative shares are. It's let's say a Stack and Dowden exceptional circumstances case, which seems to be most of the litigated cases. That question is going to matter not merely at the enforcement stage, but it's going to matter in determining what the confiscation amount should be, isn't it? So that if there's a real risk that let's say what appears at first sight to be 50-50 may actually be 25-75 against the defendant, the judge is running a real risk of making an order in too large an amount, thereby, if you like, precipitating an expensive enforcement process because the defendant simply hasn't, in reality, got resources of the requisite value to meet the order.
Yes, but those are exceptional cases, Lord, in which, for instance, a matrimonial home, which commonly arises in this case, would be anything other than 50-50, as Stack and Dowden makes clear.
Well, yes. I'm not sure the everyday experience of the Chancery Division is there as quite as exceptional as all that.
But the everyday experience of the Crown Court is less complicated, and
yeah.
And as I say, I think I've responded to your lordship before, that's a problem that pre-existed Section 160A, and therefore it may be a problem of the scheme of the Act, but it's not rectified by Section 160A.
I think what I'm really thinking is that actually it may well be that it would be sensible to exercise this power even in a case where there is a real problem that has to be sorted out, rather than just cases where there isn't a problem, if only to make the whole confiscation process proceed in accordance with a real appreciation of the value of the defendant's interest.
Yes, my lord, appropriate case, quite. But of course,
it's only when the judge can be absolutely confident of what the defendant's realisable portion is. And it just seems to me, the more that one reflects on this, it's been rare enough for the judge to be able to say to herself or himself, well, it's quite clear here what the defendant's realisable portion is. And I don't really need to get into an examination of the third party. Well, what happens if the judge purports to exercise his powers under Section 160A and it transpires that is based on a total misapprehension of the true facts? I mean, is it open? I mean, there's obviously the right of appeal, but is it open to a third party to seek to have the judge's order under Section 160A set aside?
well, the right of appeal of a third party is provided for by Section 181.
Yeah. I mean, leave aside the question of the right of appeal. It's not open to a third party to apply to the judge to set aside the order.
No, but the third party, in order that a Section 160A determination is made, the third party will be present, and or at least have the opportunity to have been present and make representations.
Yes, of course. Yes, of course.
There's a. I mean, if the third party's been notified and hasn't bothered to turn up, then broadly speaking, they're bound. But there's under 199(8)(b), there's a sort of exceptional injustice let out, isn't there?
Yes, but only if they haven't been given an opportunity.
They've had the opportunity but haven't taken it, for example.
But yes, there is. Sorry, if there's a serious risk of injustice, the let out is there. It does exist in 199(8)(b), as
8B.
the lordship says.
Or is it A?
8B.
8B, yes.
This excursus confirms, if confirmation were needed, of the utter complexity of this legislation.
Well, it did occur to me when I was considering Ahmed and Qureshi, which deals with the earlier legislation, that all the provisions that I have directed your Lordship's attention of 156 through to 159, up to 232, back to 227, were all contained within Section 74. So the complexity is on many levels.
I seem to recall in the Court of Appeal that there was a steady flow of appeals
Yes.
from the Crown Court, determinations under this Act.
Yes.
There are
Yes.
difficult
Yes.
ones.
Absolutely, and to this court also.
Yes. Right, where are we, Mr. Biddle?
Can I just simply reinforce the explanatory notes given Malone and Friends' submission in relation to their relevance, and by reference to Hansard, there's an additional document which ought to have reached your Lordships today. Forgive me, it ought to have been in the original bundle. It's Tuesday the 13th of January, and I invite your Lordships to turn to the second page thereof, where the Parliamentary Under Secretary of State for the Home Department, Mrs. Bradley, in her speech, deals with clause 1 in the second paragraph, reiterates that it is an amount to be paid rather than consideration of any assets, and the determination to rid the court at an early stage of spurious third-party claims designed to frustrate the process. But then the third paragraph reiterates that within paragraph 21 of the explanatory notes, in deciding whether to make a determination of any particular case, it's expected the judges will exercise the power to determine the defendant's interest in property in those cases where their experience allows them to do so.
So what's this add to the explanatory notes, Mr. McDowell?
Well, it simply shows it's the intention of Parliament if there's any suggestion that the explanatory notes do not reflect that.
Am I right in thinking it's only the Crown Court judge who can make the confiscation order?
Yes.
Whereas if you get an issue arising at the enforcement stage, that can be referred to any judge, is that right?
No, well, in fact, any judge can sit in the Crown Court.
Yes.
So a High Court judge could sit in the Crown Court, as indeed Mr. Justice Turner did in Taylor and Butler. So in this case, in fact, Mrs. Hilton was sentenced by His Honour Judge Kerr, and the confiscation proceedings were dealt with by His Honour Judge Miller. So, in fact, there could be a change of judge in an appropriate case if complicated matters of property law did fall to be determined. A judge could be specified.
So another option would be, say a judge decided provisionally to go down the 160A route. Notification was given to the co-owner, who comes along and puts up a big fight for saying his interest is more than 50%, let's say. At that point, the judge could adjourn it to another judge with the requisite property experience.
He could, yes.
Right.
And my lords, my lady, we say that that the various passages of Millington and Sutherland Williams that we have referred to over the course of our written case support the interpretation that we attempt to put on Section 160A, namely that it is a power. And also, without going to it, the case of Gulam makes it absolutely plain, because it's on all fours with this case, insofar as a determination was made of a defendant's share. In that case, the father claimed, and indeed his sons, who were the defendants, claimed that the properties that they held were held in trust for their father, but the order was made on the basis that he held a full share, or each defendant held a full share of the property. And so a determination of effectively 100% determination was made, but it was held that no Section 10A, which is the English equivalent of Section 160A, determination was made despite that. And again, it's a situation where Section 160A was simply not referenced in the course of proceedings, and interestingly in that case, the prosecution on appeal conceded that a determination under Section 160A was made, falling into, we submit, the same error that the Court of Appeal made in this case. Can I turn then to the second question?
Yes.
We submit that if the determination or decision by the court that Mrs. Hilton was withheld half of the property was a determination under Section 160A, indeed in relation to any determination under that section, should the judge choose to do so, the failure to afford the opportunity for third parties to make representations is nevertheless not fatal to the order. It is a situation which has come before the courts on many occasions where the Act does not provide a consequence for non-compliance. And I'll take this matter quickly because your lordships and your ladyship are well aware of the authorities of Sonji and Knights and Guraj, and what arises out of Guraj is the question of whether there is any substantial unfairness that is incapable of cure. The consequence in this case is merely that a third party's interest would be dealt with on enforcement, just as it was before Section 160A was inserted by the 2015 Act. But we submit that it's plain that when one considers the amendments to the 2002 Act as a whole, that Parliament did not intend that invalidity would follow non-compliance. For the possibility that third parties would not be so notified and not be afforded that opportunity is contemplated by the Act. It's contemplated in Section 1998B at MS 581.
Yeah.
Because a third party can make representations on enforcement if that person was not given a reasonable opportunity to make representations when the determination under Section 160A was made. And it is also contemplated by Section 181, subsection 4 through to 6. And this is something which is not included in our written case. But it is plain from subsection 4, an appeal lies to the Court of Appeal against a determination under Section 160A of the extent of the defendant's interest in property. Section 5, an appeal under subsection 4 lies at the instance of B, a person who the Court of Appeal thinks is or may be a person holding an interest in the property, if subsection 6 or 7 applies, and subsection 6 states this subsection applies if the person was not given a reasonable opportunity to make representations when the determination was made. So there is an appeal which contemplates that there may have been a procedural error within the determination under Section 160A. And therefore, any substantial unfairness which is created by that procedural error can be cured.
So it's like giving permission to appeal.
Yes.
A different test.
Yes.
We have mentioned, because we are bound to the case of McLaughlin and Grew, which followed Hilton, but we say, for the reasons articulated in our written case, that the court was wrong to distinguish Sunji, Knights and Guraj. It was suggested there that those simply dealt with procedural delay, but the overall tenor of those decisions is not in dealing simply with procedural delay, but it is a question of what follows the breach of any procedural requirement. It is not confined to simply postponement and delay.
Under section 181(4), an appeal to the Court of Appeal would be subject to a requirement of leave from the Court of Appeal.
Yes, yes, indeed.
And a time limit for bringing the appeal.
Forgive me, my lord.
And a time limit for bringing the appeal, which would presumably run from the section 160A determination.
Yes.
Now you've drawn our attention to subsections 5 and 6. First of all, I thought, well, you had an unanswerable point there. But if a person if the person wasn't given a reasonable opportunity to make representations when she should have been, why can't that person say, the result is, my lords, that the determination is void? In other words, how does it aid your case that a determination is not void if there's been a breach of section 160A2?
Because there's a remedy available to the third party. Any substantial unfairness to that third party can be cured.
Okay, thank you.
Same lords, my lady, we submit that the answer to the first question is simply this: that a judge must give a person other than the defendant who has a share in property, or may do, where the judge positively decides to make a conclusive determination under section 160A, but not when the judge simply decides on a defendant's share in property, as he was obliged to do under the original legislation. And the answer to the second question is a simple no, even if he does make a determination under section 160A. A failure to allow for representations should not invalidate the order because of the existence of the two cures available to him through enforcement and on appeal. Those are my submissions.
Thank you, Mr. O'Dolan. Mr. Broadley? Yes. Mr. Duffy?
My Lords, my lady, I intend in fact to start with an aspect of the prosecution skeleton argument and paragraph 29 of their argument, which is at MS 40 in the papers.
Yes.
The appellate states that the respondent submits that it cannot have been the intention of Parliament that third parties are required to be heard at the making of confiscation orders, which will in many cases involve the consideration of jointly held assets. Ordinarily, confiscation orders are paid. A period of imprisonment is specified in default. The consequence of the conclusion of the Court of Appeal in the present case is that determinations on third-party interests would be made in many cases in which they would, prior to the insertion of section 160A, have been unnecessary. But the reason, my Lords and my lady, why those considerations would be unnecessary is because the structure of the legislation and the consequences of the imposition of a confiscation order mean that before one can reach the stage of enforcement, one has to run the gauntlet potentially of a period of imprisonment in default, of satisfaction of the confiscation order, and then the additional hardship that might arise from enforcement proceedings. And indeed, the basic procedure, we respectfully say, under Section 156 and indeed Section 160A, needs to be considered in a manner which is compliant with Article 1, Protocol 1 rights. And indeed, that was an issue which was settled, we respectfully say, in the case of Waya, which is set out at tab 16 of the bundle of material. And the relevant section, my lords, relating to that my lords will see at paragraphs 13 and 14 of the decision of the court. Indicate that paragraph 13, Article 1, Protocol 1 is one of the convention rights to which the Human Rights Act applies. Section 1.1b. That means that Section 3.1 requires that so far as possible to do so, the legislation must be read and given effect in a way which is compatible with it. Mr. Perry QC for the Crown and Lord Panic QC for the Home Secretary both submitted that this means that POCA must be read and given effect in a manner which avoids violation of Article 1, Protocol 1, that a confiscation order which did not conform to the test of proportionality would constitute such a violation, that it is incumbent upon the domestic court to provide a remedy for any such violation, and that the appropriate remedy lies in the duty of the Crown Court judge not to make an order which involves such a violation. These submissions are plainly correct. Any such violation can be avoided by applying to POCA, and in particular to Section 6, the rule of construction required by Section 3 of the Human Rights Act. Indeed, whilst that case was concerned with the Article 1, Protocol 1 rights of the defendant, nevertheless, in a circumstance where the Article 1, Protocol 1 rights of, as in this case, a partner who has a share in a jointly held property are concerned, it seems to us that the legislation must be read in a way so as to give proper consideration to the Article Protocol 1 rights of the partner.
Well, Mr. McDowell's argument is that Article 1, Protocol 1 doesn't come into the equation here because the third-party rights are sufficiently protected, either by the circumstance that resort will only be had to Section 160A, where the matter is plain to the Crown Court judge, or alternatively, if the Crown Court judge proceeds under a misapprehension, that there is an appeal against his or her decision.
The difficulty which arises, my lord, and indeed this case is a useful example of the problems that can arise. In this case, for example, the respondent's partner did not know anything about any of the proceedings, either in the Magistrates' Court, the Crown Court, or indeed subsequently in the Court of Appeal, and therefore was not in a position to do anything about the matter at those stages.
Yes, but he knows about it now.
He does. Yeah. The further difficulty, though, my lord, is that he is then faced, as indeed other partners in similar situations would be faced with the prospect of having to decide to allow the possibility that their partner or ex-partner would be subject to a period of imprisonment, in this case a period of 6 months in default of the payment of the confiscation order, and that they would have to await the point of the appointment of a receiver and the enforcement proceedings again before the Crown Court before they could make their representations about their own interests in the property. And in practice, my lords and my lady, that appears not to occur. The prosecution at the outset of their written submissions indicated that this is a process which has two stages to it, namely the making of the confiscation order, and then the enforcement aspect of the process. But in fact, my lords and my lady, it is a process which, whilst it can have two stages to it, those stages usually are making of the confiscation order and compliance with the confiscation order. And it's entirely right, my learned friend points to the fact that in some circumstances, other family members unconnected with the criminality at the heart of the order may provide some assistance to a defendant, provide them with the means to make a payment and to avoid, for example, the possession and sale of a family home. But that doesn't really solve the conundrum at the heart of this case, which is as to when and in what circumstances are the rights of the third party likely to be protected. And in practice, we respectfully say, my lords and my lady, that those rights in practice rarely ever come to be debated or to be heard. Within the explanatory notes that my learned friend had referred, lords and my lady, to
But if those rights are not invaded, the fact they don't come to be debated may not matter. But does your submission go so far as saying the rights are in fact invaded without their extent being properly debated?
Yes, my lord.
In which case, invaded in what way?
Well, it may well be ultimately, my lords, that and when this amendment under the Serious Crime Act was being debated in Parliament, the idea behind it, and there's quite a bit of Hansard which has been included within the skeleton arguments. The reasoning behind the introduction of Section 160A, it appears, was to make the process more efficient and to avoid a situation where, for example, delays are created by the introduction of third-party interests at the enforcement stage to thwart or frustrate the making of the confiscation order. But in a case, for example, such as this, one might ultimately find, if one got to the enforcement stage, that the entitlement of the other partner was, say, 50% of the property, or perhaps 70% of the property. If it was a simple case, if it was a straightforward case of 50%, nothing to dislodge the presumption of an equal share, then the use of Section 160A would seem to be a sensible course to take for a Crown Court judge, because then it would have the benefit of finality in relation to any such determination of competing interests. It would not, in my respectful submission, create an additional hurdle within the process, because these simple cases, as my friend has described them, would in all likelihood be easily resolved by the Crown Court judge at that stage. One of the contentions within the explanatory notes is that it is better that issues relating to a determination of competing rights, given that they can in some circumstances be complicated, better that those are dealt with at the enforcement stage. But in actual fact, the court which is dealing with the determination at the enforcement stage is the same court that could be dealing with those rights at the confiscation stage. And so it is nonsensical to suggest within the explanatory notes that the Crown Court is not equipped to deal with these issues at the confiscation stage. And indeed, if they are simple and straightforward and easily resolved at that stage, then one has the additional benefit under Section 160A of that determination being binding, and therefore avoiding the possibility of further delay further down the line at the enforcement stage.
Well, did the operation of the 2002 legislation, before the introduction of Section 160A, did that interfere with third parties' convention rights?
I have to say, my lord, that on our analysis it did, in the sense that it did not provide for representation of the third party rights at the time of the making of the confiscation order.
So it was incompatible, you say, with Article 1 of the first protocol.
Yes, my lord. And in fact,
It's remarkable that that point has never been taken previously, isn't it?
perhaps, my lord, but it certainly seems as a matter of practical effect of the legislation, that whilst, as my learned friend Mr. McDowell had indicated, a defendant could, for example, call in evidence another partner or their spouse at the confiscation stage to give evidence as to what they say their share was. But outside of that, there was no right for the third party to make representations, and indeed
Until the enforcement. But at that stage, the third party's rights were not going to be interfered with, because there was no question of the confiscation of property belonging to the third party until enforcement was arrived at, wasn't it?
Yes, but what tends to happen in practice, my lord, is that in order to avoid the prospect not just of enforcement proceedings, but also the prospect of the penalty of a period of imprisonment in default, that is a very, very substantial disincentive on third parties to demand the opportunity to make representations at the enforcement stage. And I think, as my learned friend has conceded, the vast majority of these applications do not reach the enforcement stage, and therefore, whilst there is certainly a notional opportunity for a third party to make representations at the enforcement stage, in practice that does not happen by virtue of the incredible disincentives that.
Well, if the third party becomes aware of the confiscation stage of the proceedings, forgetting at the moment about 160A, is it open to the third party to make representations at that stage?
Under Section 160A, obviously they have to give the right to make those representations, but yes. Outside of Section 160A, there is no provision, my lords, my lady, for that to be facilitated for the third party. I'm sorry.
No, I didn't mean to interrupt. I just want to ask, the fact the confiscation order is made, does that have any impact on the ability of the third party to use his interest or her interest in the property to, for instance, raise money independently?
Yes, there would be, for example, my learned friend had suggested that in this case, as an example, there might have been the facility with the assistance of the other interested party to raise funds by way of additional mortgage. Now, unfortunately, in this present case, that was not possible because this was an interest-only mortgage. The amount of equity in the property is actually relatively modest, and despite efforts to the contrary, it was not possible to raise funds to satisfy the confiscation order. But one could certainly imagine a situation where, with the assistance of the third party, the defendant might raise those funds by way of a mortgage and pay over, by way of satisfaction of the confiscation order, a sum which in fact represents the proceeds not just of her interest in the property, but also the proceeds potentially of the third party's interest in the property. And one can certainly see how, for very practical reasons, that the third party's rights ultimately never get properly aired before the court and are never properly taken into consideration.
Well, you presumably say that insofar as a confiscation order is going to be paid out of a remortgage of shared property, that will always include a remortgage of the third party's share in the property.
Yes, indeed.
You can't mortgage a beneficial interest in practice and expect to get any money for it. You've got to mortgage the whole property.
Yes, that's entirely right, and obviously that would require the cooperation of the third party.
Well, only if it's in joint names.
Yes.
If it's in one name only,
no.
Then you're at risk.
Yes, that's right. That is correct. But quite often, I'm suggesting, because of the pressures and the penalties that apply to failure to comply with the confiscation order, that those third-party rights are sacrificed by reasons of convenience and expediency and the avoidance of further harm being brought to the door of the defendant. And so, in that way, Article 1, Protocol 1 rights of the third parties are in practice not being met.
Mr. Duffy, I'm sure you are right to remind us of the importance of A1, P1 here, but then, as you've just said, we have had an excursus for the last quarter of an hour on the rights of the third parties. I had slightly expected you to say, what about the A1, P1 rights of the defendant? If it turns out that the available amount was far too highly calculated, as a result, the recoverable amount was far too highly calculated, and she's been the subject of an order enforceable by imprisonment, which does not reflect a proper calculation of her assets.
Well, that's entirely right, my lord. If, for example, she was unable to, on the basis of an assessment of, say, 50% of the property, she was in reality not entitled to that extent of the property, she may well then struggle to raise that amount, and obviously would then face the consequences of.
Yes, but
is that
at the confiscation order stage, she had the opportunity to make all those representations, didn't she?
She did, my lord. She did, my lord. But in this case, she.
And Article 1, Protocol 1 is a qualified right.
Yes, my lord.
And if interference is presumed with the right, then the justification surely is the provision to the person affected of the opportunity to adduce evidence to avoid the confiscation order being made, or being made in the terms that it was. And I can't really see how you can assert a breach as opposed to an interference with Article 1, Protocol 1, if there is in place a system whereby representation to a court can be made, which could bring about a modification of the order.
I suppose it might only arise, my lord, if subsequently it transpired that her interest in the property was not what she thought it was. But I agree, my lord, that she would have the right to make representations.
Well, I think my question at the back of my mind was not the wife who says, this is joint names, I'm entitled to 50%, but the wife who says, this is joint names, but in fact, my former husband has a 90% interest. I've only got 10%. And the Crown Court judge says, rubbish, it's 50%. And the Crown Court judge turns out later to have been wrong about that.
Yes.
I think that may have been at the back of my mind.
Yes. Well, I think in those circumstances.
Would that be an interference with her A1, P1 rights? Because what the Crown Court judge would have done would have made a confiscation order in an amount which involved an overvaluation
Yes.
of her share in the property. Would that be an interference?
But I suppose in that way he is, the error would lie with his assessment of the evidential basis of the order.
But there's an appeal available against that.
There is.
Yeah.
There is.
Thank you.
And is a mere I understand your point that a third party, let's say the partner, the co-owning partner, would in many cases probably not stand up and assert his or her interest in the property, but would remortgage it to make sure that his partner, who was the defendant of the criminal proceedings, stayed out of prison.
Yes.
But is that sort of disincentive itself an interference with the co-owner's A1, P1 rights?
Well, we say it's a practical interference, and indeed, in the course of the argument, we referred to the observations that were arose in the case of Paulette, which is a tab 2 of the bundle of authorities, my lords, my lady, and and indeed, if Lords and my lady turn to MS page 173, and this was a case concerning an issue as to whether or not, in fact, the applicant had properly had an opportunity to make representations about his Article 1, Protocol 1 rights in the course of proceedings before the domestic courts. At the bottom of page MS 173, the last 4 lines, and this is under the heading of the court's assessment, the ruling reads, although the second paragraph of Article 1 of Protocol number 1 contains no explicit procedural requirements The court must consider whether proceedings as a whole afforded the applicant a reasonable opportunity for putting his case to the competent authorities with a view to enabling them to establish a fair balance between the conflicting interests at stake. And this, of course, was relating to proceedings which predated the decision in Waya, which identified the need to interpret the legislation in a way which was Article 1, Protocol 1 compliant. But we respectfully say that whilst there is a notional opportunity for a third party to make representations, having that opportunity confined to the enforcement stage, which was the position prior to the introduction of this amendment by the Serious Crime Act, is in effect to deny a proper opportunity to make representations about those rights, to be heard about those rights.
Yeah, sorry, I just want to be clear, and I mean this is a question by way of inquiry rather than challenge. If a third party became aware of confiscation proceedings, would it not be open to him or her to make representations at the confiscation stage of the proceedings?
They could certainly attend court, my lord. They could ask to be called to give evidence by the defendant in that case, but they would not have any right to make any representations. And indeed, I have had this very particular situation in the Crown Court in Northern Ireland, whereby a wife of a defendant who wasn't aware of the proceedings, in fact, up until the day of sentencing, who wanted to make representations before the court, but was unable to secure legal aid, for example, in order to allow her to do that. So ultimately, she was, for practical purposes, unable to obtain any assistance to make representations at that stage of making of the confiscation order. And indeed had also, as a consequence of the offending behaviour coming to light, had become estranged from the defendant. So while certainly there is a possibility that the third party could appear at the court and could seek to assert their rights, certainly there's no guarantee, of course, that they would either know about the proceedings
Right.
or
But if they do know about it, there's no statutory prohibition on their making representation to the court, I mean, subject to legal aid considerations.
But it seems to me, my lord, that
But I mean, is that right, first of all?
I think if we can answer this way, my lord, that it seems to me that if that was right, it would seem to be utterly unnecessary then to include within Section 160A a provision which requires the court to take representations from those third parties when making a determination about the interests of the defendant in the property. In a practical sense, yes, the third party could appear at court. But on what basis, my lord, would they have a right to be heard before the court in terms of what is their standing in relation to?
Well, couldn't they simply ask the judge to consider going down the Section 160A route?
Yes, they could, my lord. So
that then they would be given a standing by virtue of the obligation to give them an opportunity to make representation.
They could, or indeed the defence representative could argue to the court and say, well, this is an obvious case for Section 160A. The third party is engaged in this and
is here.
And is here and wants to be involved in it. And then the court can proceed down the route of Section 160A. And indeed, if it's a case, as in Stack and Dowden, where there's nothing to complicate the issue of their percentage ownership, it's the kind of decision which might very, very easily and readily be made by the Crown Court judge, and the confiscation order that is then made has the benefit of not being open to further possible challenge for the same reasons at the enforcement stage. But so whilst that is all possible in practice, it seems, as in this case, there was in fact no involvement of the third party at the making of the confiscation order. And as with all of those orders, a very significant disincentive for them to ever make representation at any stage. Given the fact that the majority of these orders are complied with and do not proceed to enforcement. It seems therefore that in practice third-party representations on their Article 1, Protocol 1 rights seem to be the exception to the rule. Whilst the discussion in Parliament about the purpose of Section 160A was not focused upon, well, certainly not entirely focused or even substantially focused on third-party rights, there was at least some reference to the fact that there are genuine claims from third parties which it might assist being dealt with at an earlier stage. But the use of Section 160A, which seems to be envisaged within the discussions in Hansard, certainly seems to be advocated as an improvement to the system in terms of its efficiency and in terms of its ultimate success, by avoiding the need for more expense and more cost, which is inevitably caused by the appointment of a receiver and subsequent Crown Court proceedings at a later stage. But in a very practical sense, my lords and my lady, the third-party interests are not protected unless, not properly protected, we say, unless the Section 160A procedure is used. And therefore, in circumstances where it appears to the court that the terms of Section 160A are met, and indeed it will not be the case where the terms of the legislation could be held to be applied. These are quite specific circumstances and will not arise, in fact, in every case. And if one goes back to the wording of the section, there are a number of matters that the court has to be satisfied of, and not just that there is a property in which the defendant has an interest, in which another party has an interest, but also the court has to be satisfied that Section 1A, there is property held by the defendant that is likely to be realised or otherwise used to satisfy the order. So it will only be in circumstances where that jointly held property is likely to be realised or otherwise used to satisfy the order. And there may well be many cases, for example, where there are other assets available to the defendant which are not jointly owned, which are more than sufficient to meet the recoverable amount. And there may equally be cases, my lords and my lady, where the terms of Section 160A 1A are satisfied, i.e. that there is a property which is jointly held, which is likely to be realised, either, for example, by way of remortgage or by way of sale to satisfy the order, but whereby the equity in the property is of such an extent that the Crown Court judge may well feel it unnecessary to determine the particular level of interest held in the property by the defendant or third party before going on to make the confiscation order. So it's not in every case, my lord, or even I respectfully say in a majority of cases where the requirements of Section 160A will be found to exist by the Crown judge. But where they are found to exist, it seems to me that the Article 1, Protocol 1 rights of the third party are clearly engaged. There is inevitably likely to be an interference with the property which they have an interest in. And under the current scheme, outside of Section 160A, there is in fact no practical basis upon which their rights can be properly represented to the court.
Right.
In terms of it might be useful, my lord, if I look at the question of or the second question at this stage, my lord.
Yes.
The defining part of the Gullum judgment is paragraph 31, my lords, my lady.
I'm so sorry, which page are you on?
Sorry, it's tab 6, page 229.
Thank you.
And it's paragraph 31 of the judgment. Sorry.
Oh,
Sorry, I do apologise. It's not. It's sorry. It's garage tab 7, and it's paragraph 31. And of course, the prosecution or the appellant has suggested that the learned judge in this case on appeal has distinguished the reasoning in Soneji and Knights. We respectfully say that is not the case.
I'm sorry, which page are you on?
Oh, sorry, it's MS 269.
Ah.
Yes.
And the paragraph reads, so what then is the answer to the question of section 1411 is unavailable? When does a procedural error prevent the making of a confiscation order and invalidate such an order if it is made? Consistently with the Crown and Soneji and with the dominant purpose of POCA, that confiscation is the duty of the court, which a significant priority is to be given. The answer is not that every procedural defect does so. The correct analysis is not that a procedural defect deprives the court of jurisdiction, which would indeed mean that every defect had the same consequence. Rather, it is that a failure to honour the procedure set down by statute raises the very real possibility that it will be unfair to make the order, although the jurisdiction to do so remains, and that unless the court is satisfied that no substantial unfairness will ensue, an order ought not to be made. This is not to deprive Section 14.2 of effect. It remains effective to remove the peremptory bar of Section 14.11 upon quashing confiscation orders on grounds only of procedural defect connected with postponement. Where Section 14.11 applies, no such defect can alone justify quashing. Resulting unfairness, on the other hand, may, but such unfairness cannot be inferred merely from the procedural breach. Where Section 14.11 does not apply, a procedural defect not limited to postponement will have the effect of making it wrong to make a confiscation order if unfairness to the defendant would thereby ensue. If, however, the defect gives rise to no unfairness or to none that cannot be cured, there can be no obstacle to the making of the order, and this is what the duty of the court under POCA requires. The present case is one where no unfairness can be or is suggested. Cure does not arise. If it were to arise in another case, it is possible that there might be ways in which potential unfairness could be cured. They might include, for example, determining, in accordance with WIA, that the confiscation order must be adjusted to achieve proportionality. In a few instances, it might be possible to vary and inadvertently impose sentence within 56 days, as permitted by Section 155 of the Powers of the Criminal Court Sentencing Act 2000. And indeed, there's a similar provision under the Judiciary Act Northern Ireland 1978. In others, the correct outcome may be that it is the forfeiture order which ought to be quashed by way of appeal rather than confiscation order. Priority for the latter is, after all, built into POCA. Each case, however, must depend on its facts. And so, of course, the test, my lords, which is to be applied, really requires two questions. First of all, what was parliamentary intention in relation to the effect of a breach of the procedural requirement? And then secondly, has any unfairness arisen so as to affect the fairness of the making of the order? In the present case, my lords and my lady, there is, we respectfully say, a procedural unfairness which arises if a court were to proceed to make a determination under Section 160A and not permit representations to be made by the third party.
You say that His Honour Judge Miller did make an order under Section 160A in this case. I mean, he wasn't referred to it.
No.
He doesn't advert to it, and there's no reference whatever to the obligation contained in the provision to give the third party rights consideration. So, I mean, it does seem to partake of a situation where the court proceeded in ignorance of Section 160A, and therefore, Mr. McDowell says, inevitably under the procedure that existed before Section 160A was introduced.
But he certainly did not specifically aver to Section 160A, but the way in which the matter was regarded by the Court of Appeal was to take the view that he had nevertheless made a determination of the defendant's interest in the property, whether he expressly indicated that he was doing so as a consequence of Section 160A or not. He nevertheless made such a determination.
But in effect, what the Court of Appeal seems to have said is that because he was required to make an order under Section 160A, whether he adverted to it or not, the validity of his order falls to be determined by the application of 160A.
Yes.
I may have misunderstood your earlier submissions, but I didn't understand you to say that in every instance where a court is contemplating making a confiscation order, it must proceed through the Section 160A route.
No, I'm not suggesting that it must, because there will be circumstances in which it is not appropriate to do so.
How is the Court of Appeal's judgment explicable other than that it considered that the Crown Court had to proceed through the Section 160A route?
Well, on the basis that the Judge Miller, in his assessment of the confiscation order, specifically refers to the 50% interest in the property of the defendant. And it seems that the Court of Appeal took that by identifying a specific share in the property, that he was determining the extent of her interest in that property. So it was, as for example, in comparison to the Gulam case, where there wasn't anything on the transcript in that case to determine or to demonstrate that in fact a determination had been made in this present case, because the Crown Court judge specifically identified a percentage share of the property attributed to the defendant, that was regarded as the judge, whether he knew it or not, was regarded by the Court of Appeal as the judge making a determination, and that determination then fell foul of Section 160A, whether he was aware of the section or not.
So on every occasion when a judge makes a determination of the percentage share in a property, he or she is bound to follow the Section 160A route. Is that right?
Yes, Lord, that's what we say.
Then you say the 160A must arise in every case of shared property, doesn't it? Because, as I understand it, the court, in making a confiscation order, must identify the available property.
Yes.
And that requires the court, in every case, to value the defendant's interest in any shared property.
Although if for example, my Lord, the court has to first of all identify the benefit that has been derived from the criminal conduct. Once it has identified the benefit that has been derived, it then has to assess the available amount.
Yeah.
If the available amount far and away exceeds the amount of benefit.
Well, I see a situation
well,
where, but you say in every case where the value of the shared interest, the co-ownership interest matters, you say they have to go down the 160A route.
But only if it appears to the court that it is likely that that property is to be realised for the satisfaction of the order. So it would only, for example, if, there was a benefit of £10,000 and the court then determined that the available amount held by the defendant was, say for example, the defendant had £20,000 in savings, plus also an interest in a jointly held marital property. The court may well simply proceed then to determine the confiscation order and the amount of the benefit, because it is not required, it's not likely that the jointly held property will be required to be used to satisfy the order. So in those circumstances, in fact, Section 168 does not apply. It only applies if the court is of the view that the jointly held property is likely to be realised in satisfaction of the order. So Section 160A really only applies in circumstances where there is where the court assesses that there is likely to be interference in some way with the property to satisfy the order, and where that property is jointly owned.
But use would include a remortgage.
Yes, that would be correct. Yes, so So yes, that would be right. It's realisation or used. Used, I suspect, probably does extend to the process of remortgaging them.
So it's not just a situation where the judge thinks there's likely to be enforcement against the property. It's the much more ordinary everyday situation where the co-owner, if he's told or she's told, says, well, we better remortgage it to keep you out of prison.
Yes, and I suspect that probably is a very common reaction to this particular type of factual circumstance.
But you say, therefore, that in every remortgage, every what you might call likely remortgage situation, the judge, you say, must go down the 160A route, because that will satisfy the likely to be used test.
Yes, yes. And it also has the advantage of respecting the Article 1, Protocol 1 rights of the third party, and also avoids the potential for either imprisonment of the defendant in default or the cost and expense of enforcement proceedings later. I see the time, my Lord. I'm not sure if that's...
Well, how near are you to the end of your submission?
Well, I'm open to rehearsing any aspect of the respondent's skeleton argument which my Lords might feel might assist. There are sections within the skeleton argument which highlight the parliamentary debate in relation to the matter. There's also, my Lords, my Lady, the question as to what use can be made of the explanatory notes in this case. Yeah. We cite from Benyon on statutory interpretation about the potential dangers of reliance on the explanatory notes to the exclusion of the ordinary language of the section and the parliamentary intention.
Would you like to develop that this afternoon?
I don't imagine I'd be very much longer, my Lord, but just a little bit longer this afternoon.
Yeah. Well, we'll adjourn now and sit again at 2 o'clock.